Okay. Great. Hello, welcome everyone. I'm Janice. I'm the managing attorney of the Low Income Taxpayer Clinic here at Maryland Volunteer Lawyer Service, and we are very excited to have Russ Haynes here to speak with us today. He is an authority on the treatment of tax liabilities in bankruptcy, and I'm going to let him tell you a little bit more about himself. Thank you, Russ, for being here.
Yeah, thanks for having me. I am an attorney in private practice in Northern Virginia. I have worked with my dad for, since I was a kid in various capacities. And he is a former IRS Criminal Investigation Division Special Agent and CPA. And we have done tax controversy work together for many, many years since he left the IRS in the early 1980s. I graduated from George Mason University Law School with a tax concentration and immediately joined the Virginia Bar. And rather than working at a big firm downtown somewhere, I decided to continue working with my dad. I like the commute a little bit better, but we do exclusively tax controversy work involving the IRS and the states. And my specialties within that sphere are employment tax and TFRP cases. Most of my portfolio of work involves companies with multi-million-dollar tax liabilities and exposure of multiple corporate officers and employees to trust fund recovery penalties. And my second specialty is the treatment of tax liabilities in bankruptcies, usually individual bankruptcies, but how to properly determine when bankruptcy is going to be part of a solution for someone, when that bankruptcy should be filed, and how to get far enough down the road for that bankruptcy to have maximum effect, and with the IRS and the states having as little, doing as little damage to that client before the bankruptcy petition gets filed. So today we're going to be talking about how to know when bankruptcy, which is really the nuclear option for income tax liabilities, how to know when bankruptcy is going to be part of the solution, when it can be filed, what kind of resolution the bankruptcy is going to provide to your client, and what other alternatives are available, which is part of knowing when bankruptcy is really something that you should be looking at. You're going to hear most often from people, well, I thought taxes weren't dischargeable in bankruptcy. I get that from accountants and other attorneys all the time. And the answer is yes, in fact, taxes, if they are the right kind of taxes, and they are old enough, can absolutely be resolved in a bankruptcy. But those of you who are bankruptcy practitioners know that there are a lot of other questions that need to be answered before you just file somebody's bankruptcy petition, especially after the 2005 amendments of the Bankruptcy Code, and we have the means test and all that sort of other stuff. So initially, we have to determine what effect would a bankruptcy have on your client's tax debts. And this question is always has a temporal component, because what happens to the taxes in the bankruptcy depends on when the bankruptcy is filed. The other considerations before you decide to recommend to a client, yeah, you should just file bankruptcy, or tell them in the converse, bankruptcy is not going to be any help to you, is how much pressure is the IRS or state tax authorities exerting on this poor, hapless client. And then you also have to consider, based on that client's circumstances, what other options do they have? Could they possibly sell an offer in compromise to the IRS? Are they part of the 3% of people who submit an offer in compromise to the IRS and that offer gets accepted? So you have to do some financial analysis. Sometimes you also have to take into consideration the age of the tax liabilities. If they're coming up on the CSEDs, the collection statute expiration dates, do you want to put them into bankruptcy 6 months before the balance expires under the statute of limitations? if the IRS isn't exerting a lot of pressure on them. So there's a lot of moving parts. You have to weigh the benefits, the detriments of the bankruptcy, what kind of pressure is being put on them, what other options they have before you make a decision to put them into bankruptcy. So with that being said, let's jump into the effects of the bankruptcy on the tax liabilities. Bankruptcy practitioners, you guys can go to sleep. I'll wake you up in a couple of minutes. The first effect, though, that the bankruptcy has is that the automatic stay arising under Code Section 362 is applicable to all creditors, including the IRS. So IRS collection action has to stop, except they can continue to do certain things that people often confuse with IRS collection action. If your client has unfiled tax returns, the IRS can still demand that those returns be filed. They can do all sorts of other stuff. You can read this list for yourself. Most of them are pretty self-explanatory. One of the ones that you see most often is the assessment of trust fund recovery penalties against an individual taxpayer who has filed bankruptcy. It used to be that those TFRPs could not be assessed while the individual taxpayer was in bankruptcy. That changed a while ago, and they often do that now. They can continue with audits, including the issuance of a stat notice. They can issue summons. They can refile previous liens, but they cannot do things like issue levies. They cannot file a new tax lien. Is that any better? Can you guys hear me now? We get a response. Okay. Hopefully that's an improvement. I'm not seeing any follow-up here on the chat window. So continuing on, in order to determine when the bankruptcy can be filed, you have to classify the tax claims for purposes of the bankruptcy. And tax debts are classified, tax debts are classified like other debts. Are they secured? Or are they unsecured? The most important classifications we're going to talk about are priority versus non-priority, and whether they are dischargeable or non-dischargeable. The IRS can be, of course, a secured creditor if they have filed a lien prior to the filing of the bankruptcy petition. Remember, the automatic stay prevents them from filing a lien after the bankruptcy petition has been filed. They can be unsecured if they didn't file a lien prior to the bankruptcy petition, or they can be partially secured and partially unsecured if they filed a lien, but that lien doesn't attach to sufficient equity in the taxpayer's property. But the meat and potatoes of all of this really comes down to priority and non-priority. There are 3 time-based rules that you have to apply to your client's tax liabilities to determine when a bankruptcy would have some benefit to them. When can I file their bankruptcy petition in order to wipe out as much of their tax debts as possible? Well, you have to calculate 3 dates. And the first 2 dates are calculated under 507A8. Those 2 rules, which are rules of priority, include the 3-year rule, what we call the 3-year rule, which is 8A1, and the 240-day rule of A8-2. The 3-year rule, if you look at the statutory language, says this. And if that makes sense to you, good. If it doesn't, here's the English translation, okay? A tax debt is a priority debt if the return was due with extensions less than 3 years prior to the filing of a bankruptcy petition. Okay, so what does that look like? Well, like everything in life that is unclear, we use a spreadsheet. Okay, if you look over here, here's the 3-year rule. So let's take tax year 2015. All right, tax year 2015, it was due April 18th, 2016, plus 3 years is April 18th, 2019. Okay, so that 2015 liability is a priority debt until April 18th, 2019. If they filed an extension, now it's a priority debt until October 15th, 2019. Okay? 3 years from the due date with extensions. Let's go on to the next rule, the 240-day rule. That one says this in the statute. That's a little more confusing. And there's more to unpack, right? There are a couple extra little presents in here for us. If the tax was assessed within 240 days of the petition, extended by the time an offer in compromise was pending or in effect plus 30 days, and any time during which a previous bankruptcy affected a stay on collection plus 90 days, all right? Let's unpack it a little more. Here's the English translation. If the taxes were assessed less than 240 days prior to the bankruptcy petition being filed, they are priority debts, okay? Note that the filing of a tax return is not the assessment date. The assessment date is the date the IRS or the state tax authority processes and posts the tax return, okay? The 240-day period in the statute is extended by the time an offer in compromise was pending plus 30 days, or the time a prior bankruptcy was open plus 90 days. So let's see what that looks like. We'll go over here to our 240-day period, and let's say the 2015 tax return was filed on time. We'll ignore filing for now. And let's say they posted it in a month later, May 15th, 2016. It remains a priority debt until January 10th, 2017. But note, the 240-day rule usually doesn't have any impact because 240 days is the fastest of the 3 time periods, okay? But if there was an offer in compromise with respect to that tax in effect, you would have to extend that time period by the time the offer in compromise was pending plus 30 days. So if the offer was pending, let's say 300 days, that's optimistic. You have to add 300 days plus an additional 30. There's your extended 240-day rule date, okay? This analysis is impossible without Excel, just so you know, all right? Now, 2005 made all of this a little bit more complicated because we got the addition of this flush paragraph at the end of 507A. And that flush language added an otherwise applicable time period specified in this paragraph, which could be either the 3-year rule or the 240-day rule, right? Those are both applicable time periods specified in that paragraph, are suspended for any period during which the IRS or the state tax agency is prohibited from collecting a tax. I changed this, right? Read with me in green first, because I think it makes more sense this way. Is prohibited from collecting a tax as a result of any request by the debtor for a hearing and an appeal of any collection action taken or proposed, plus 90 days, and they have to be prohibited from doing that under applicable non-bankruptcy law. So there's two elements there, right? And then there's an extra one. This plus any time during which a stay of proceedings was in effect in a prior case that's a prior bankruptcy case plus 90 days. That's the rule of Young, which used to be an equitable tolling rule, being codified in statute. That's another seminar. So let's talk about this a little more, because this actually has an impact. What is applicable non-bankruptcy law? Well, what's the order of authority in life, right? It goes God, Jesus, the Bible, Internal Revenue Code, Treasury regs, and then state statutes, right? Applicable non-bankruptcy law, code, regs, or state statute. So if the IRS is prohibited from collecting a tax, they have to be prohibited by some provision in the Internal Revenue Code or the Treasury regulations, okay? So what sort of things does that include? Well, the IRS is prohibited from taking levy action, enforced collection action, by a timely request for a CDP hearing, yeah? A request for an installment agreement, request for an offer in compromise. Well, which ones activate that flush paragraph to 507A? Does a CDP hearing, if you file it timely, it certainly stops the IRS from collecting a tax. It's certainly a request by the debtor for a hearing. So it would look like the CDP hearing meets that requirement. And we have to build into our 3-year and 240-day rule calculations the time that CDP hearing is pending. What about a request for an installment agreement? The IRS is stopped by statute from issuing levies while a request for an installment agreement is pending. So they are prohibited from collecting a tax by applicable non-bankruptcy law. Does it trigger the language in the flush paragraph? Yeah, we're good. They're prohibited under applicable non-bankruptcy from collecting a tax as a result of a request by the debtor for a hearing. Is a request for an installment agreement a request for a hearing? No, it is not. So a request for an installment agreement does not trigger an extension of the 3-year or 240-day periods. So that should set off alarms for those of you who do this sort of stuff. We can request an installment agreement for our client, stop the IRS from taking collection action, and the bankruptcy clocks keep running. Very important, okay? What if the IRS comes back and says, your installment agreement is bogus, he can afford $5,000 a month instead of the $5 a month that you offered us, we're going to reject it. Okay, so they reject your formal request for an installment agreement and you file an appeal. What about that time that appeal is pending? Well, that's a horse of a different color, right? Because now the IRS is prohibited from collecting a tax under applicable non-bankruptcy law because of a request by the debtor for a hearing. Now you have to toll your 3-year and 240-day periods. What about an offer in compromise? No, right? It's not a request by the debtor for a hearing, even though the IRS is stopped from taking levy action while an offer in compromise is pending, but you don't need the flush language. Oops, wrong button. You don't need the flush language to deal with an offer in compromise. It does not stop the 3-year rule, but the statutory language itself, giving us the 240-day rule, includes an extension for the time an offer is pending plus 30 days, okay? So an offer does not toll the 3-year, but it does toll the 240-day, right? As you can probably see, this calculation can get a little complicated, right? Let's talk some more about CDP hearings because that needs to be unpacked a little bit more. The CDP hearing triggers an extension of the 3-year and the 240-day rules under the flush paragraph to 507 because the IRS is prevented from taking levy action, but only in response to a timely CDP hearing request. Timely means filed within 30 days of that final notice of intent to levy, whether it's a letter 1058, an LT11, a CP90, whatever it is, you have to file your 12153 within 30 days of that notice being issued. If you file it late, you can get an equivalent hearing, and that still gets put on the transcript as a request by the taxpayer for a hearing. What happens? The IRS usually withholds collection action while an equivalent hearing request is pending, but they don't have to. They're not prevented by statute, by applicable non-bankruptcy law, from taking collection action while an equivalent hearing request is pending. So you have a chance to go to appeals, talk about an installment agreement, talk about an offer in compromise, protect your client from levy action, but if you file your CDP hearing request 31 days instead of 30 days after that due process notice, you get all the benefits, but you don't toll the 507A periods, right? Sometimes we will intentionally file a late CDP hearing request because we know that client is headed for bankruptcy. And we want to talk to the IRS about some sort of interim payment plan, installment agreement that is going to be able to get them 14 months, 16 months down the road until they can file bankruptcy. And we want to have that discussion with appeals rather than some one of Despicable Me's minions working in ACS in Philadelphia. But we don't want to extend the time that the bankruptcy can be filed. We want to file it in 16 months, not in 24 months. So everything that you do is a chance for planning, okay? Let's talk a little bit more. You guys know that you can request a CDP hearing in response to 2 notices. One is a final notice of intent to levy, and whether, like I said, whether that's a letter 1058, an LT11, a CP90, whatever it is, it's final notice of intent to levy is required by the Restructuring and Reform Act of 1998, okay? The other one is a lien notice. If the IRS files a lien, they send you your due process notice along with the copy of the lien notice and says you have 30 days to request a hearing in the IRS appeals office in response to this lien. This is a little more information on why the statute is. Wait a second. Excuse me. Yeah, that's more explanation. Ignore that. Okay. And they go on the transcript as the same thing often, right? It actually says request by the taxpayer for a CDP hearing, and then in parentheses it says levy or lien. It doesn't always differentiate, but there's a huge difference for purposes of this bankruptcy analysis. The IRS is barred from taking collection action for a CDP hearing filed under Section 6330. That's a levy notice. But they're not barred from taking collection action while a CDP hearing request filed under Section 6320 is pending. That's a lien. So if your 507 analysis swings on the time the IRS is barred from taking collection action by applicable non-bankruptcy law as the result of a request by the debtor for a hearing, then CDP hearings, which the subject of which is a levy and the subject of which is a lien, are treated differently. If you request a CDP hearing in response to a levy, the IRS is barred by applicable non-bankruptcy law from taking collection action. Your client has filed a request for a hearing, and you have triggered an extension of the 3-year and the 240-day rules. If you request a CDP hearing in response to a lien notice, the IRS computer still prevents levy action from being taken in most cases because there's an appeal pending, but The Internal Revenue Code does not prohibit the IRS from taking levy action while a CDP hearing, the subject of which is a lien, is pending. There is no extension of the statute of limitations as a result of a CDP hearing requested in response to a lien. And if there's no extension of the statute of limitations, it means the IRS isn't barred from taking collection action. And if they're not barred from taking collection action, you don't extend the 507A periods. So I hear this a lot also. Well, what about interest and penalties, right? If you look at an IRS transcript, you'll see above the current balance, you'll see accrued but unassessed penalties and interest. For purposes of the 240-day rule, which is 240 days from date of assessment, as you look down the chronological listing on the account transcript, you will see additional assessment dates as penalties, additional failure to pay penalty under 6651A2 is assessed. You'll see an interest is assessed. You'll see multiple assessment dates. For purposes of this analysis, for the 3-year and the 240-day rules, additional interest and penalty assessments relate back to the original assessment date for the tax, okay? You don't have to run another 240-day analysis from each incremental assessment of penalty or interest, okay? Thank God. All right, let's go on to the third rule, which I'm sure you guys that we're looking at our spreadsheet, you can see that there's 3 rules, right? So we have the 3-year rule, we have the 240-day rule, and then we have what you will see is the 2-year rule, which comes from Bankruptcy Code Section 523. Unlike 507, the 523 provision deals not with priority or non-priority, it deals with dischargeable or non-dischargeable. And the statutory provision provides as follows. Let's read it in English. Tax liabilities cannot be discharged in a bankruptcy if the return was filed less than 2 years to the bankruptcy petition, right? Or wasn't filed at all, right? 2 years from never is never. BAP-CRAPA, Bankruptcy Abuse Prevention and Consumer Protection Act, which we call the Bankruptcy Prevention and Consumer Abuse Act, or just BAP-CRAPA around here. One of the worst pieces of legislation ever bought and paid for by the bank and credit card industry. But that changed this quite a bit. Chapter 13 used to be very, very useful for dealing with taxes that we couldn't deal with in Chapter 13 and had all sorts of special provisions. But after that law, the 2-year rule applies both to Chapter 7 and Chapter 13, so make no distinction there. There's a couple of rubs in here. It's a pretty clear-cut rule. If you file your bankruptcy tomorrow and you're seeking to discharge a tax liability for 2005, let's say, but you never filed the tax return, it's not subject to discharge. You have to give the IRS and the states at least 2 years between when you file that return and when you try and blow off this debt in a bankruptcy. There's a few complications, though. One is, what is a tax return? That seems pretty self-explanatory to most of us who are tax practitioners, but it's actually not that clear. For many years, we've had this Beard test, which says in order to be a tax return, the document has to give the IRS enough information to properly compute the tax liability, and it must show the taxpayer is making an honest attempt to comply with the tax laws. Thus, you get one of these people who come in and they were, you know, a Benjamin Bannister follower, or they come in and start talking about how they're a sovereign citizen of the United States and blah, 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 and they don't need a driver's license to drive and taxes are unconstitutional. If they file some garbage document purporting to be a tax return that reports 0 and then writes across the 1040 in big letters, sovereign citizen, that's not a tax return. That's a frivolous filing. It's a And a frivolous return is not a tax return because see above, right? As per Beard, it doesn't give the IRS enough information to compute the tax liability. It's not an evidence of an honest attempt to comply with the laws. So that's a pretty clear case. Well, what about a not so clear case? What about a tax return assessed under Section 6020 of the Internal Revenue Code, which gives the IRS the authority to compute and assess tax if the taxpayer decides they just have other stuff to do other than file a tax return, right? Well, a 6020 assessment by statute is supposed to be good and sufficient return for all legal purposes, except it's not in bankruptcy. Many courts held that once a substitute for return assessment was complete, it's not a tax return at all. And 2 years from never is never. So the prevailing rule is that a completed SFR is not subject to discharge in a bankruptcy, no matter when the bankruptcy is filed. But in 2005, we got an addition to Section 523, which actually added a definition of tax return for purposes of Section 523. And it includes a return prepared pursuant to 6020A. That's when the IRS comes to the taxpayer and says, hey, you didn't file your tax return. And the taxpayer actually responds and cooperates, and they sort of come up with a tax return together. This is the proverbial Brigadoon assessment, right? The 6020A assessments are extremely rare. Or, this is important, a written stipulation to a judgment or final order entered by a non-bankruptcy tribunal. That could include what? The tax court, right? IRS issues a stat notice of deficiency. You respond with a petition. You stip out with counsel's office, and the tax liability is assessed pursuant to an order of the United States Tax Court. Well, that constitutes for bankruptcy purposes a tax return, right? So 2 years after that tax court order, that tax is potentially dischargeable, right? But it does not include a 6020B assessment, right? So if the IRS starts an SFR and they issue a stat notice, your only chance to save it from that point is to go to tax court. That's the only way to preserve bankruptcy dischargeability. All right, so there's a lot of gray area here. If you see on a transcript 1040A, substitute for return, you got yourself a bit of a pickle. And that's probably more complicated than the scope of this discussion can really handle. But I leave this information in there for your perusal later. And if you have questions about that, feel free to call me. I'll try and help you walk through it and figure out from the transcript what's going on. But often, the only way to figure out whether you're dealing with a true SFR or not is to file a Freedom of Information Act request, get copies of exams files, including a stat notice, because the stat notice is really the shibboleth in determining whether a tax assessed potentially pursuant to 6020 is a true SFR or not, and thus constitutes a tax return or not for purposes of Section 523. But the basic rule is that if the IRS gets to the point in their SFR that they issue a stat notice, it's an SFR. If they haven't issued a stat notice, your guy files the tax return, it's assessed, it's accepted by the IRS, that's a tax return, and you can get rid of it in bankruptcy. There's a couple of little complications here. One of them is a line of cases that is spreading through several circuits like a real cancer, and it like other horrible things, came out of Mississippi, and it's called McCoy, and we often refer to it now as the one-day late rule. If you look back to the definition of tax return provided in BAPCRAP in Section 523, it says in accordance with applicable filing requirements. And the McCoy case, the Mississippi State Tax Commissioner said, well, this guy here, he filed his tax return late. And one of the applicable filing requirements is that these tax returns are due by X date. And so, yeah, he may have filed a tax return, but he didn't file it in accordance with applicable filing requirements because he didn't file it by the deadline. And thus, it's not a tax return. A tax return filed late is thus not a tax return for Section 523 purposes, and it's not subject to discharge. And they won. And that's now the rule in several other circuits too, including the 1st and the 10th. So if you practice in the 1st, the 5th, or the 10th, you got a problem. If your client filed a late tax return, you have a problem. More on McCoy. Amended returns, right? For the IRS purposes, an amended federal tax return is sort of a non-event. There's only one tax return, and there's no provision requiring the filing of an amended return. But remember, the definition of tax return includes language that says return or equivalence report or notice. But for IRS purposes, you do not have to run a second 2-year clock based off the filing date of an amended return. You do have to run a second 240-day clock off the assessment of additional tax if your amended return reports additional tax. The state, on the other hand, and this is something that came out of Maryland, this Ciotti case, it's possible for state law to require the filing of an amended return or an equivalent report or notice that requires the running of an additional 2-year clock. And that was the case in the Ciotti case. Maryland state statute requires a taxpayer to file a report of federal adjustments within 3 months of the IRS making adjustments to the federal return. The taxpayer in Ciotti didn't do that, and the resulting tax was held to be non-dischargeable. A pitfall for the unwary. One of the biggest mistakes that we see is taxpayers who get audited by the IRS, they do not file a report of federal adjustments within the 90-day period. Maryland gets wind of it directly from the IRS 6 months later, makes a non-filer assessment, non-dischargeable. Non-dischargeable. What about penalties? Penalties in bankruptcy. If the event giving rise to the penalty was more than 3 years in the past, you may be able to strip it off. So let's say you have a non-dischargeable tax. It's an SFR. It's some other, whatever it is. You have an SFR, the IRS has assessed late filing penalty, late payment penalty, failure to make estimated tax penalty. You file the bankruptcy 3 years after that failure. You can't get rid of the tax and the interest because they're non-dischargeable, but you could get rid of the penalties. So even in cases involving SFRs, sometimes bankruptcy does have some benefit. If the underlying tax claim is itself dischargeable, then the penalties go too. There are different types of penalties. Certain penalties are not subject to discharge, such as trust fund recovery penalty. But other penalties, like civil fraud penalty, negligence penalty from an audit, you can get rid of those too. All right, so you've done your analysis, right? You know that this taxpayer, this is unrealistic because they only owe 15 grand. It's kind of old. But you've done your analysis, right? You know that for 2012, here's a perfect example. They filed a return, then they got audited. The IRS did an audit for 3 years. They scooped up 2012, 13, and 14. The audit adjustments were made 2 years later. 14 straggled behind a little bit. They filed on time, so we don't have a problem there. So what's driving the date that all of this can go away in bankruptcy? It's the 3-year rule, as is often the case. They had a CDP equivalent hearing filed, but no extension because it was an equivalent hearing, correct? We just listed on here to confuse you. Actually, I listed on there just to make sure that everything is accounted for. These folks also filed an offer in compromise, but because of when it was filed, it was after these 240-day periods already ran. So the answer for them is, yeah, you can file Chapter 7 after April 15th next year, 4 or 5 months from now, and you can get rid of all of this. There are other considerations, though. One of them is this. You have to look at what would happen after the bankruptcy, right? Bankruptcy is an in personam remedy. It deals with your client's liability to pay the taxes. It does not relieve their stuff of its liability to pay their taxes, i.e., if the IRS has filed a notice of federal tax lien and that lien attaches to any assets, that lien doesn't go away as a result of the bankruptcy. The lien would survive the discharge. Okay? So one of the things that's always helpful before you make the decision to recommend bankruptcy is get a collection information statement prepared. See what assets they have. What, if a lien has been filed, what assets are attached by the lien? What assets would the IRS demand in the course of a negotiation be liquidated or borrowed against, right? What would happen after a bankruptcy to those assets? If the IRS is going to demand monthly payments from them. So for our example, these folks, they're not going to be able to file for another 4 months. If the IRS is exerting a lot of pressure on them, what would the IRS demand from them in monthly payments? So if they had to make payments for 3 months until they got to next April, how much would that cost them? If the IRS said they could pay $3,000 a month, and it's going to cost them $9,000 to make 3 months worth of payments, then the marginal utility of the bankruptcy in April is only $6,000 because they're going to pay $9,000 of the $15,000 that they owe. So doing a collection information statement is a critical part of the analysis here. You don't know whether bankruptcy is the solution until you consider how much will it cost them to get to the bankruptcy and what sort of deal would they be able to get with the IRS or the state if they choose not to file bankruptcy. Yeah, that's the information about the lien, okay? There's a lot of slides in here about how, after this point, about how assets are treated between various chapters or in the context of an offer in compromise that can sort of help you guide your decision making between trying an offer in compromise or trying a bankruptcy. Deciding to go with an installment agreement instead of a bankruptcy, or an offer in compromise instead of an installment agreement. But the first 2 parts to the analysis are the same with everybody. Are the tax liabilities dischargeable? When would they be dischargeable? Are they priority? When would they become non-priority? i.e., when could a bankruptcy be of some use to these folks? Then you have to look at financial situation, assets. If they file a bankruptcy and discharge $300,000 worth of tax liabilities, but they have a $1 million house that they own free and clear, well, the house is going to be at risk in the bankruptcy. The IRS has filed a lien. The lien would remain attached to the house. If their intent is to save the house, well, then the bankruptcy isn't going to help because the lien would remain on the house, and there's a good chance the trustee would decide to administer the house and pay the $300,000 to the IRS. So bankruptcy analysis, financial analysis is the only way to make the decision between whether bankruptcy is going to help somebody or not. And with that, that's 5 minutes over my allotted time. I'm supposed to leave 20 minutes for questions. I apologize. If there's any questions, let's open it up for questions now.
If anyone has any questions, feel free to type them into the question box, and then we can read them from here. or the chat box. That works also. I don't see any at the moment. Let's see. Okay. I don't see any questions at the moment. This is really very confusing stuff. And I think it sounds like we need just to take it step by step then when we see a client with these issues then.
Mm-hmm. Yeah, absolutely.
Oh, wait, here's a question here. We have a question here where the question is, can you recommend a simplified tool similar to your spreadsheet that is readily available?
No. The short answer is no. Unfortunately, the spreadsheet is something that we've developed over a number of years because it's the best way to do the analysis, and it allows you enough flexibility for each individual taxpayer's situation. You have to get the account transcripts. Some people may have prior bankruptcies. I just did one last week for a serial bankruptcy filer. He had filed 7 bankruptcies in the past, let's say, 12 years. And I had to compute the extensions to 507 as a result of the prior bankruptcies. Plus, there's another issue out there with 523. Equitable tolling still is sort of being argued by the federal government in other contexts, and I think it's only a matter of time before we see it raised in order to extend the 2-year time period. So you need a tool that is going to allow you to make calculations like this. But it's relatively simple to do it in Excel. So take a look at the spreadsheet here. If you look in the formula bar, you can see that for 2005, this calculation, this date is merely this date plus 365 times 3 plus 1 for a leap year. So the spreadsheet is actually calculating this 3-year period for us. Same thing here, 365 times 2. This one plus 240 days. And you can alter that analysis to be anything that you want. So the other thing Excel can do is calculate the number of days. So for example, this offer and compromise, we need to know how long it was pending, right? We know that it was filed August 21st, 2016. It was rejected and the appeal period expired April 5th, 2017. Well, that means it was pending. See if I can get it to highlight those 2 boxes. Yep. That box minus that box, right? April 5, 2017 minus August 21st, 2016 expressed as a number, 227 days. There are services out there. There's one that I know of for sure. I think it's offered by I've talked to the guy. I can't remember his name. I think it's called Tax Discharge Determinator or something like that. It's another tax lawyer, bankruptcy tax guru who makes a service available. You get your client's transcripts. You send him the transcripts. He does this analysis for a fee and sends it back to you. And some people have asked us to do that. I get a request, once a week from a bankruptcy attorney who has a client come in and say, hey, I owe these taxes, and the bankruptcy attorney, knowing what they know now, says, oh my God, this is really complicated. I don't have the spreadsheet. I don't remember all the rules. I don't think I want to do this. I don't think my malpractice insurance carrier wants me to do this. I got to find somebody to do the analysis. There are tools out there that would allow you to do that. But in our experience, the best way to do it, the most customizable and easy way to do it is with the spreadsheet. And if you want the spreadsheet, send me an email. I'll send you the spreadsheet. It's yours. Enjoy.
Great, thank you. We do have another question here. It's in regards to personal property tax lien and how that's involved with this, or how do you treat this?
Personal property taxes?
Personal property tax lien, yes.
Yeah, as far as I know, that's a dischargeable tax liability. But like any tax liability that is secured by a lien, that lien is not stripped off in a bankruptcy, right? The lien survives the bankruptcy. Does this client have other tax debts or other reasons why bankruptcy would be a good solution?
Alexander, if you could let us know. Let's see. No, sorry, there's no additional information regarding that question.
Okay. Yeah, liens are the big one. If you have somebody come in and they owe a bunch of taxes and you think that they're non-priority and they're dischargeable and the IRS hasn't filed a lien, you got to run down to the courthouse, because once that lien is filed, unless they're a client that has nothing, right? Because what the IRS does in a no asset Chapter 7. Let's say they filed a notice of federal tax lien prior to the bankruptcy petition being filed, and your client has nothing. They don't have a house. They don't have cars. They don't have retirement. They don't have anything like that. The value of the services lien is fixed as to the value of the assets on the petition date. So if the value of the assets on the date of the bankruptcy petition is 0, then after the bankruptcy case, sometimes the IRS will just release that lien. It just goes away. And sometimes they do that even in an asset case where that lien would remain attached to assets that survive the bankruptcy. Sometimes they screw it up. But if you have a client that has significant assets and there's a notice of federal tax lien or multiple liens already filed, and the IRS is likely to proceed against those liens even after the discharge, then the bankruptcy might not be as good a solution for them. You have to keep in mind that the liens survive the bankruptcy, and as long as the liens survive, the service's ability to pursue collection based on their liens survives along with them.
So I think the follow-up that we have is that this is potentially in relation to a 401k. Does that make sense?
Yeah, 401ks, qualified retirement accounts are usually exempt property when it comes to the bankruptcy estate, meaning that they're not available for the trustee to seize and liquidate for the benefit of the person's unsecured creditors, the debtor's unsecured creditors. But liens, specifically tax liens attach to any and all assets of the taxpayer wherever located, and often that includes retirement accounts. And one of the situations we see most frequently with a tax lien surviving the bankruptcy is a person that has significant money in a retirement account that the trustee can't take and give to the IRS, but the IRS could come along after the bankruptcy waving their lien in the air and say, hey, you have all that money in the retirement account, we would like it, please. That's a very common situation.
Okay, we have a few more questions here. The next one is, can you talk about the naked debtor doctrine, where the IRS declares its tax lien prevails upon all of the debtor's pre-petition property?
The treatment of liens pre and post bankruptcy is a rabbit hole that we could do an entire other seminar or series of seminar on.
Okay.
So I'm not sure we want to go down that rabbit hole. But suffice it to say for purposes here that if there is a lien filed and your client has significant assets that even if they would be protected in the bankruptcy would remain tantalizing for the IRS post-discharge, the chances are good that the IRS will come along seeking collection from those assets after the discharge. It's something that they never used to do. They were very bad about it. But now it's become largely an automated procedure where somebody who's gotten a discharge, they will get a letter a couple of months later saying, hey, this is the IRS. Congratulations on your discharge. Hey, by the way, that lien that we have and all the stuff that you have, we'd like it, please.
Okay. We have one additional question. Does the lien survive the bankruptcy only to the extent of the value of the assets as of the date of the filing of the bankruptcy case, or to the full extent of the
Yeah, that statement is correct. In a Chapter 7, the services lien rights are fixed to the value of the pre-petition assets as of the petition date.
Okay. Great. I think that's all the questions. Okay. Wonderful. Thank you. I think that's all the questions at the moment. We've had some very interesting questions. And thank you all for joining us. Thank you, Russ, for taking a very complicated topic and trying to make it understandable for us.
My pleasure.
Really helps to break it down a little bit and walk it through these rules. So it sounds like really we just need to kind of walk it through each of these rules very carefully and slowly and with the aid of a spreadsheet to really try to understand the best option for the clients then moving forward.
Yes.
Great. Well, thank you. Thank you very much. Thank you, everyone, for listening, and thanks for joining us. We're going to sign off now, so we're going to stop recording.